So thank you so much for joining us for the second part of this program on women on courts. I'd love to introduce you both, and I'm really grateful you could join us at least online. And I know that in Europe it's much later, so you had a long day. We are very truly grateful you can be with us. And so let me introduce both Judge Perisin and Professor Iyiola Solanke, and also, of course, my colleague here, Professor Laure Clement-Wilz. And then we will open the panel by having Judge Perisin talking for about 10-15 minutes, and then after Judge Perisin, we'll have Professor Solanke continue our conversation for another 10 or 15 minutes, and then I will have Professor Laure Clement-Wilz continuing. We'll open it up to your questions, and then we will take it from there. So first, let me say that I'm thrilled to have these three not only brilliant academics, but Professor Perisin is also Judge Perisin, and she graduated from the University of Zagreb in 2002, received master's from Oxford, a PhD from the University of Zagreb. She was a Fulbright scholar both at Georgetown and Michigan, and of course, she was also a visiting professor in various prestigious universities, including Harvard University. But mostly today, she joined the court. She joins us as a member of the General Court since 2019. She also widely published on European law and the influences on US law on European law. So we're thrilled she's here with us for this session. She's been very vocal from when I know her on feminist issues. And so we thought she would be a terrific contributor to our panel for today. Our second speaker, Professor Iyiola Solanke, is now a chair of European Union law at the University of Oxford, where she's Jacques Delors Professor in European law. And she has a wealth of expertise in European law, combined with her focus on anti-discrimination, racial integration law, with a strong commitment and activism in the intersectional equality, both in academia and in the legal profession. Her work focuses on anti-discrimination legislation, social movements, and the judiciary. She has worked on governance in the European Union through historical, empirical, social legal approaches. She's the author not only of a EU law textbook, but two important monographs entitled Making Anti-Racial Discrimination Law and Discrimination as Stigma, a Theory of Anti-Discrimination Law. So finally, Professor Solanke convenes an international forum which investigates Black experiences and the police across Europe, and founded the Black Female Professor Forum to empower and create greater solidarity for Black women in academia. Last and not least, and I'm grateful she could join us in person from Paris, Professor Laure Clement-Wilz, who teaches European law at Paris-Est, Créteil, where I had the pleasure to join her this summer for a terrific symposium on a program she runs, founded by the French Agency of Research on Francophonia, Plurilingualism, and language policy. She has written two important monographs on European law. The first one is on the role of the Advocate General at the European Court of Justice, and her second monograph is on the Court of Justice, focusing on internal functioning of this institution and the institutional interaction of the court with other political branches. She also edited a book on the European Court of Justice as a political actor, and we're both interested in working more on the role of women at the European Court of Justice in a very broad and intersectional sense. So without further ado, I will open up with Judge Perisin. Thank you for joining us and welcome.
Thank you so much, Fernanda, for the invitation. Thanks also to Federica. And it is wonderful being again in a panel with Laure, and nice meeting Iyiola this way. I spent last weekend in Oxford and her name was mentioned so many times that it was unbelievable. Today I decided to speak about three issues. So the presentation will have three parts. parts. The first part is, does it even matter whether judges are men or women? And this might be a bit controversial for this panel and for this forum, but it is not a controversial question in mainstream EU law. My second is part of the presentation will concern diversity at the Court of Justice, and I will put an emphasis on gender. And the third part will be, focus on what has been done and what could be done more in order to enhance the gender balance at the European courts. So turning to the first part, does it even matter whether judges are men or women? Now, I'm asking this question because continental Europe is largely dominated by legal formalism. So the starting point of legal formalism is that legal norms are clear, objective, and neutral. So there is only one way of reading these norms, and judges just have to be the mouth of the law. There is here mostly the version called soft formalism, which says that even when the norm is vague, one can look at other norms, typically the higher norm or the preamble, to find the correct legal reading of this norm. So according to formalists, so anyone who knows the law well will decide a case in the same way as any other person who can read the law well. So the only thing that is important is learning the law well. So it doesn't matter whether you're a man or a woman, black or white, come from a poor background, from a rich background. Everyone who learns the law, how our professor taught us, will know how to decide the case. Now, legal realists and critics would obviously disagree. And in the US context, there has already been a lot of research showing how the background of a judge and his personal characteristics, his or her personal characteristics, might affect the outcome of the case. But there has not been so much research in the EU context. And in the US, there has also been research on the outcomes of appeals. I read once, I remember an article that on appeal, judgments written by female judges are more likely to be struck down than judgments written by male judges, because judges at the higher court were typically male and gave more deference to male colleagues. So in the EU context, there is no research on this, and the conventional wisdom is that the gender of a judge makes no difference for the outcome of the case. Still, even in the EU context, it is important to know that gender balance is still seen as important, but for different reasons. It is seen as important for giving more legitimacy to the court. So this diversity is seen as a pillar, as an element of legitimacy. Then also diversity, gender balance are considered to send a positive message to junior lawyers, and maybe also open the door to new female lawyers entering into the field, although there is not much research on that either. I've heard that female judges are more likely to hire female referendars, but I don't have any data on this. So that would be maybe interesting to see. Now, turning to the second part of my talk, this is the principle of diversity at the EU courts. So the Court of Justice really prides itself with diversity. First, we have diverse nationalities. So out of 27 member states, there is an equal number of judges per member state so as to guarantee this diversity. Also, for Advocate General, there is one per, let's say, big member state, which has a specific legal order, and then a rotation of the smaller legal orders. Then we have great diversity of legal backgrounds. We have academics, judges, practicing lawyers, civil servants, so on. We also have diverse age groups, because the entry age for the court is not really set. It says at least 12 years of working experience, but possibly less if someone is exceptional. We have judges from their early 40s up to the what we could call the retirement age, or even beyond the retirement age. But the court is not so diverse in other respects. And for today's panel, I want to focus on gender. So what about gender at the Court of Justice of the EU? So historically, of course, the court has been composed only of men. Nowadays, female judges present maybe 25 to 30% of the members of the court. A percentage is a bit higher at the general court, where it's around 33%, than at the court, where it's something like 22, but this changes. However, if you look at leading positions, there is less diversity. So at the leading positions, typically one does not find women. So we have excellent presidents and vice presidents of both the Court of Justice and of the General Court, but they are men. There was once a female vice president of the court, but never a female president or vice president of the General Court. And this is partly due to seniority, because in order to reach those positions, one usually needs many mandates at the courts, and female judges are relatively new to both courts. So also at the level of the presidents of chambers, president of committees, there is much less diversity. If one looks at other people working at the court, so not just judges, then the institution prides itself with the fact that it hires more women than men. So women constitute maybe 60% of the total staff of the court. But then again, the leading positions like the registrar of the court, of the general court, these have so far only been men. The referendaires are law clerks, which are seen as the most valuable parts of our teams. They're more, there is a gender imbalance there as well. Now, of course, comparatively speaking, the situation is not much better at many other courts. The Supreme Court now has maybe a better balance than historically. My stagiaire, Anna Marie Robertson, who might be listening now, she studied in the UK at Cambridge, and she did some comparative research for me. So one of the things that she drew my attention to was that at the UK Supreme Court, there are currently more men named David than there are women. Now, of course, it's an accident that there are 3 men named David, but there is 1 woman. It's an accident that there are 3 Davids, I assume, but maybe it is not an accident, but a structural problem that there is only 1 woman. Now, what is being done, turning to the third part of my talk, is what is being done about the gender imbalance at the EU courts. So I will here focus on the judges, not on other positions. So looking at the judges, for the General Court, a positive step was that a special provision on gender balance has been included in a piece of legislation. So the regulation 2015/2422, which provided for the enlargement of the General Court, so that the General Court would have 2 judges per member state and not just 1 judge per member state, provided that the aim of this reform is also that member states would choose for those positions 1 woman and 1 man. This is explicitly mentioned. Now, this, of course, has limitations. The first limitation is that this is only for the General Court. There is no comparable provision for the court, even for the member states which have both, for example, a judge and an advocate general. There is nothing comparable. And another limitation is that this provision just sets an aim, but there is no enforcement mechanism. So many member states still nominate only judges of 1 gender. There are, for example, some member states now, it is not maybe nice to mention them, but let's say Greece or France. So even Western European countries that in a way pride themselves with gender equality would have 4 members of the court, all of the same gender. So 2 of the General Court and 2 of the court, all of the same gender. Now, our institution has also made symbolic steps to make it more inclusive and to send the message of equality. So this symbolic step included the feminization of titles. So our working language is French, and the French Academy does not endorse the female version of some occupations, but we have here, despite the objection of the Académie Française, we have introduced terms Madame la Juge, Madame l'Avocate Générale, Madame Présidente de la Chambre. Now, what more could be done? So perhaps there could be more detailed provisions recommending gender balance, either for the general court or for the court or for the institution as a whole. Or maybe there could be some mechanism of at least monitoring whether gender balance is observed. Now, of course, I cannot comment on judicial appointments, but it would certainly seem interesting to look at the national nomination procedures, to what extent women participate in national nomination procedures, and whether there are any barriers to their participation. I know that in the context of the European Court of Human Rights, some steps were taken. For example, member states must ensure that women participate in the national nomination procedure because they must propose 3 candidates and one must be of a different gender than the other 2. And they've also taken measures to assess whether there are barriers to the entry of good candidates. So are there reasons maybe why certain good candidates would be deterred? And this typically women could be deterred by the fact that they would have to move to another country where there is no support of the extended family, where it might be difficult to organize childcare and so on. Typically, sometimes these rules that seem neutral on their face can have a disparate effect on some categories. And also another thing that could be useful would be for academics to actually do more research on the importance of this diversity of judicial decision making for the legitimacy of courts, maybe for the outcomes of courts, or for any other reasons. Because as I said in the beginning, Europe is predominantly believes in legal formalism. So according to many of my colleagues, it does not matter who the judge is. That would be all for now.
Terrific. Thank you so much, Judge Perisin. And we're moving on to Professor Solanke. We could have the floor. Thank you for patiently waiting there. Thanks.
Thank
Please.
you, Fernanda, and thanks to you and Federica for the invitation to speak at this exciting event. And it's nice to meet you too, Tamara. I'm sorry we missed each other in Oxford last weekend. So the title of my talk is Where Are All the Black Judges in Europe? And I'm really going to follow on where Tamara left off. And I'm going to talk about racial diversity in the European courts. And I'm going to identify specific challenges related to racial diversity and then try to suggest some new opportunities that the court might have to address this. So I actually published a paper of that title in the Connecticut Journal of International Law a few months ago. So excuse me for looking down, but I'll be reading little bits out from the article. So to begin where Tamara ended, the European Union has actually had a long-standing policy to promote gender in diversity in gender in the judiciary. So there has been a program under the title Building a European Area of Justice since the early 2000s, since around 2003. But that wasn't the start of the program for gender diversity in the judiciary. Increasingly, the Court of Justice actually had started to take a role in making decisions which promoted gender diversity. And the appearance of female judges in the Court of Justice did take place alongside the development of the gender equality jurisprudence of the court. However, whilst there are now more women in the Court of Justice, none of them are Black. So the European Union doesn't have a broader agenda for judicial diversity, despite the fact that for over 20 years, the European Union has made progress on other aspects of discrimination. So in order to justify why I think racial diversity is important, I can turn to the words of US Supreme Court Justice Sonia Sotomayor. She has, of course, persuasively argued, and I'm sure you're all aware of her argument, that the value of diversity in the judiciary lies in the contribution to judgecraft, the contribution that personal knowledge and understanding of discrimination can bring to judicial decision making. And alongside this, there is, of course, the other value, such that the perception of fairness of a judiciary that is reflective of society can deliver. So I make three arguments in the paper, but I'm not going to go through all of them. But I talk about the importance of diversity, but I try to stress that diversity doesn't have to be approached in a highly individualistic way. So I try to move away from the hyper-individualism of diversity and suggest an approach that considers diversity as that takes a public health approach to diversity. So rather than thinking about individuals and having individuals of different racial backgrounds or different ethnicities in the court, that we think about this in a more collective way and think about it from the perspective of the institution rather than the perspective of the individuals. So using this approach to diversity would mean that we take a more multi-level approach, and we would take a more interlinked approach. So we would think about diversity not just for the difference it would make to the way in which judges look, but also to the difference that it would make in judicial decision making. So the second part that I want to talk about are the challenges to racial diversity in the Court of Justice. And I suggest that there are three main challenges. These can be categorized as practical in relation to the recruitment procedure, which still generally passes through the national judicial systems and national governments. Secondly, there's a pedagogical challenge which relates to access to legal education and training. And thirdly, there's a political challenge which relates to the politics of race. So as I said, the first challenge is the method of recruitment and nomination that is set out in European Union law. And to this day, it still requires the national governments to identify individuals to nominate and to decide upon those individuals. So it's if you have racial homogeneity in the national legal system, then that is automatically going to be replicated in the European legal system, given that mode of recruitment. The second issue, which feeds into that first problem, is access to legal education and training. In the United Kingdom, for the last 20-25 years, there have been projects to widen access and to promote participation of students from underrepresented groups in legal education. That isn't replicated in other member states. So you continue to have, even at the university level, a racially homogenous law schools, which means that the profession is then also inevitably going to be primarily white. And feeding into that problem is the third political issue, which is the issue that race is really not recognized as a salient social category in most European Union member states. The issue of race is avoided as one for discussion because it's not only as Tamara said, that there is this formalism in relation to the judiciary, but also in relation to society. So that there is very little public discourse or very little public debate on the issue of race. And in fact, it's often the case that the person who complains of racism is then accused of themselves being a racist. So all of these things feed in together to limit the scope for a racially diverse judiciary at the European Union level. Now, what can be done? Well, I think that there are some new opportunities, and the primary opportunity that I talk about in the paper links to the existence of diversity charters and corporate social responsibility. So the European Union has since 2004 set up diversity charters across the member states to promote and support best practices in diversity management, not only in companies, but also in public organizations. And these diversity charters are founded on the principle of diversity as a core value for the European Union. The legal basis for the adoption of these charters is wide. It includes Article 18 and 19 of the treaty. It includes the equality directives, and it includes, the equality employment directives, and it also includes a number of directives relating to equal treatment between women and men. So there is both a project, an agenda within the European Union, and a strong legal basis for the adoption of diversity charters in both public organizations and the private sector. And we can, of course, argue that the courts are public organizations. Beyond the European Union, there is even a global agenda for this approach of diversity charters and corporate social responsibility. So, for example, there is the United Nations Global Compact, which currently has more than 12,000 signatories in over 100 countries around the world. So this idea of the use of diversity charters is one that is being adopted globally. So this wouldn't be an anomaly for the European Union to adopt this approach. So I would then suggest that a diversity agenda for the Court of Justice will serve the interests of society by not only strengthening judicial decisions, but also strengthening democracy and the health of public institutions. There has to be a multi-level approach because, as I've tried to explain, the issue is not merely that there are too few judges in the Court of Justice who are neither white nor male, but also that there are too few Black judges in the member states. There are also too few legal clerks, practicing lawyers, law professors, and law firm partners across the European Union that are Black and female. So to address this issue, the agenda cannot just focus on the European Union judiciary alone. It must include action at the national level. And I suggest in the paper that the Court of Justice initiate this broader diversity agenda by incorporating a diversity declaration into its statute. And a model for this could be Goal 3 of the ABA, which emphasizes the full and equal participation in the legal profession by minorities, women, persons with disabilities, and persons of differing sexual orientations and gender identities. So that's something that the Court of Justice could adopt of its own initiative. It wouldn't need to ask the member states for permission to do this. It could simply revise its own statute as a way of kickstarting this broader diversity agenda. The President of the Court of Justice could work with the President of the Commission and the President of the Council of Ministers to create a joint working group on diversity in the Court of Justice to promote judicial diversity as well as diversity across all of the other institutions, because unfortunately the problem is replicated there. So it would be preferable for the action to be embedded in a clear long-term strategy, but just as with gender diversity, progress could develop alongside the jurisprudence before the establishment of a formal agenda. So until the Court of Justice or the European Union feels that the political climate is correct to adopt this agenda, then progress can be made through jurisprudence, just as was the case with the gender agenda. And I'd just like to finally say something in relation to the argument for judicial diversity, quoting the ABA, which argues that a diverse court is more just, productive, and intelligent because diversity, both cognitive and cultural, often leads to better questions, better analyses, better solutions, and better processes. A broad range of views can lead to better answers for our complex world because it keeps us from discarding meritorious resolutions out of hand. It provides us with new information about the contours of the legal problem and potentially produces new and better solutions. So a final statement, diversity in the Court of Justice of the European Union is therefore to be pursued because it promotes healthy public institutions and improves democracy in the European Union. So racial diversity in the Court of Justice is not to be sought just for the sake of difference, but because it will improve the quality of democracy and public decision-making in the European Union. And I'll end there. Thank you.
Thank you so much, Iyiola. This was terrific. Also, very inspiring. Please, Laure Clement-Wilz, Professor.
Thank you. First of all, I would like to thank Federica Bindi and Fernanda Nicola for their invitation at this conference and on this very important issue and for their warm welcoming. I'm also very happy to meet again Tamara and Iyiola, that was, even if it was a long time ago. I argue today that, in line with what has been said before, that representativeness is a key concept for judging, and that this concept could help to implement legal reforms of the selection process of European judges. My presentation will develop three main points. The first point is about the selection process of the European judges and its impact on the composition of the court and on the appointment of women judges. The second point deals with judging as a professional activity in a supranational multilingual court, which is the European Court of Justice. And in the third point, I will explain why representativeness is so important for the European Court of Justice. So first of all, the selection process, it has been already explained. Just as you understood, each member states present one candidate, and then a committee set up by the European Treaty, which is composed of former judges of the European Court of Justice and current judges of national Supreme Courts, gives an opinion on candidates' suitability to perform the duties of judges and advocate general. This committee is called 255 committee because it was set up by the Article 255 of the Treaty of the Functioning of the European Union. So we will call it 255 committee. So this 255 committee checks the command of EU law and the independency of each candidate. These candidates shall then be appointed by common accord of the governments of the member states. And it happened, this committee has been existing since 2010, that the governments of the member states has been always following this 255 committee opinion up until now. So this 255 committee happened to have taken a very important role in the selection process. And this committee took also the initiative to publish an annual report, which provides further details on the condition to be judges And this report is also mostly followed by the states when they select their own candidate before presenting them to the 255 committee. For example, following this report, in line with this report, more and more states recruit their candidate following an open competition and a public hearing. So does this selection process perform well in terms of women representation? Some figures has been already given by Tamara. Just to explain, there are two courts within the Court of Justice of the European Union, the General Court, dealing with judicial review of acts adopted by the European institution, and there is another tribunal called the Court of Justice, dealing mainly with references made by national judges for preliminary ruling. The General Court is composed of 2 judges per member state, so there are 54 judges at the General Court, and the Court of Justice is composed of 1 judge per member state and 11 advocate general. Why is such a difference between the composition of the General Court and the Court of Justice? This is due to the modification of the statute of the Court of Justice of the European Union. And the statute doubled the number of judges at the General Court. The statute was modified by a regulation adopted in 2015. And when adopting this regulation, the European Parliament, who was a co-legislator, added a preliminary recital in the text, stating that, and I quote this text, "It is of high importance to ensure gender balance within the General Court. In order to achieve that objective, member states should gradually begin to nominate with the name of choosing 1 woman and 1 man." And this preliminary recital in this regulation did have an impact, even though it was only a preliminary statement, and even though the treaties, the European treaties, do not state anything about respecting the principle of non-discrimination in the composition of the court. So after this report, we can, like, at the General Court, 18 judges on 54 are women, which makes 33%. Another figure is like in total, only 16 states on 27 have nominated at least 1 woman. So it means that 11 states still have 2 men judges in the General Court. So the General Court performed pretty well, but could perform much better if all the member states were nominated at least 1 woman. Moreover, at the Court of Justice, so the second court, women are clearly underrepresented. Currently, it is composed of 7 women judges on 27 and 3 women advocate general on 11, which makes I calculated 26% of the total number of members of the court. So even if the current figures are better than they used to be, the Court of Justice is still a male-dominated court. And there is also discrepancy among the member states. Countries like France, Belgium, Denmark, Sweden, Greece, Luxembourg, Lithuania, Hungary has no women judges whatsoever, either at the General Court or at the Court of Justice. So in that context, what reform could we implement to improve women presence at the Court of Justice? Some academics, such as Sally Kenny or the current president of the Court of Justice of the European Union, Con Lennartz, suggest that effort should be made in the recruitment of judges, of national judges, and training of students. And it is, I think, also what Iyiola Solanke suggests when pleading for better inclusion of Black and minority ethnic law students and a better recruitment in the national bench. I would qualify this approach as a bottom-up approach. It is a very important one. The main problem I see here that it could take a lot of time, and it depends a lot on national government willingness to endeavor such a reform. Also, another problem here I see that at the ECJ, the member state can present only 1 candidate. So anyway, it has to choose between women and men. Therefore, I argue that what we should favor, that we should favor a European Union incentive in order to change the selection process. So it is more like a top-down approach that I would favor. The European Union could be such a promoter of such a change because there are a set of non-discrimination legal instruments, and there is a solid jurisprudence in this court that improved gender equality in the workplace. Therefore, the European Parliament was fully legitimate when it added this preliminary recital in the regulation of 2015, although the impact was limited to the General Court. To go even further and increase the number of women at the Court of Justice, I think this 255 committee should take its leading role seriously and ask for more diversity to the member state in its annual report. This conclusion brings me to my second point on judging as a professional activity in a court such as the Court of Justice of the European Union. The Court of Justice of the European Union is a supranational court and a multilingual court. As I said, it is divided in two courts, and then just let me explain that the proceedings turn to be very different from what someone could think of. Applicants and defendants are mainly companies or European institutions or states. When the Court of Justice decides preliminary rulings, it addresses national judges and not private parties. The Court of Justice does not deal with the fact, but only with interpretation of EU law. Moreover, the conditions to be a judge or an advocate general stated in the European Treaty put forward two main aspects, their statute and their mission. Their statute focuses on their independency. A judge can be qualified as a judge because he or she is independent. And their mission focuses on their expertise in EU law. This brings to this idea that law is neutral, and law being a third language between parties, law bears its own vocabulary and its technicity. Law entails a sort of, or judging entails a sort of distance between the judge and the parties. Judging is an activity that does not naturally goes with representation. And it seems to particularly hold true at the EU level, where judges answer to companies, institutions, or national judges and not private persons. However, I claim that this specificity of the European judges and of the European Court of Justice is not an obstacle to promote diversity in the court. So in this third and last point, I will explain why representativeness is so important for the European Court of Justice. Representativeness refers to the image of justice, how the justice is seen to be done. In order for anyone to be able to see himself or herself in his or her justice, a court such as the Court of Justice must be diverse. We want a justice that does not give the image of protecting a dominant group, which would be white men. As Solanke said, systematically excluding groups of citizens raises important question of legitimacy, irrespective of whether their presence would change the outcomes. And this notion of representativeness is already accepted in the European Union system. Indeed, there are one or two judges per member states. So representativeness already applies to the states. So why shouldn't we apply representativeness to women? Then obviously the following question would be, where do we start and where do we stop this quest for representativeness? Minorities, and then which minorities? religious, age, sexual orientation. Gender is only one aspect of an intersectional approach. So I would conclude that diversity of the composition of the court does not prevent that court from being composed of people with very similar cultural and educational background. A young American scholar demonstrated that the most common point amongst European judges are their education, their professional profile. So it demonstrates, his name is Cutter, that extra legal setting factors that bring them to adopt decisions in favor of supremacy and efficiency of EU law. And here we touch on the main problem of the European Union as a democratic project, because it is focused on its own efficiency. In increasing the presence of women in the European courts goes along with making European Union less technical and more political. Thank you.
Terrific. Thank you so much. So let me, first of all, thank you to all three presenters. I thought it was terrific, and all three presentations had lots of overlap and talk to each other. I just want to remind you that here in the US, federal justices under Article 3 of the Constitution are not doing much better than the statistics we heard from our panelists. In fact, we have 60% that were men, 39% who are women, and going to Professor Solanke's point, 71% are white. So in a very multicultural environment like the US, where there should be lots of diversity represented, also the federal judiciary is not doing better. And the Biden administration has pledged for nominating more diverse judges, including more women, women of color, Latinas, etc. If you look at our Supreme Court, we have the highest number of women represented, 2 white and 2 women of color, but certainly only 1 Republican and 3 Democrats, and overall 3 judges of color. So this is to say that despite the Supreme Court has provided with lots of changes, yet the federal judiciary Article 3 judges is not much better than what we heard in the European courts, European Court of Justice at large, with the highest court and its 2 general courts. I wanted to circle back before opening up to your questions, and I know that Judge Perisin and Professor Solanke will leave us in 10-15 minutes, depending from their busy schedule. I wanted to go back to both of them to see if they had any follow-up on thoughts on what was said, or more of a conversation with each other over the issue we just heard about, including I think the 3 of them framed the problem of diversity in different terms, and also whether it's more of a gender or intersectional diversity that is due to race or class and how we get to this court, but also different proposals on what to change at the moment. So if we can, if Judge Perisin or Professor Solanke have something to say, otherwise I'll be happy to open it up to our audience. Please, yes, Professor Solanke.
No, but also the people who are at home, you can ask questions.
Thank you, in the chat. Thank you, Federica. Yes,
thank you. Thank you. And it's lovely to see you again too, Laure. It's been a very, very long time. Thank you for your presentation too. And I suppose the point that I wanted to pick up on was this idea of representativeness. So in my paper, I talked about judges reflecting society rather than representing. And I think I would prefer to use the word reflective, because when you talk about representation, it does give rise to some of those concerns that you mentioned. And I think when we try to when we move into that territory, well, there's no real answer to those concerns, because then it becomes, you know, a never-ending story. So I prefer to use the term reflecting. And for me, that speaks more to the idea of justice and the need for justice to be seen to be done, and the idea that a court that reflects the society will be recognized as being more legitimate by those who are the beneficiaries of judicial decisions, and who judges and courts are designed to serve. And I think for me, the emphasis is more in terms of the you know, the idea, as Sonia Sotomayor said, that a more diverse judiciary that reflects society is also then more able to tackle the complex realities of all aspects of that society. So those judges are not representing any particular constituency, even though in the US many judges are elected. But in relation to Europe, I'm talking about judicial diversity as being important to reflect those different experiences in society, not in a kind of representative way. Even though I liked your point that, you know, nationality is represented and linguistic diversity is represented, but I think I would nonetheless prefer to use the idea of reflection for racial diversity rather than representation. Thanks.
Terrific. Thank you, Iyiola. And I have another follow-up comment on this, and also goes to for the presentation of Judge Perisin. So when she was Judge Perisin told us that the classic legal formalist answer to why should we have women judges is that women and men decide in the same way. But we just heard from Professor Solanke about this reflection on this complex reality, and also Professor Clement-Wilz addressed this. So, I was wondering, is there something that could perhaps, I'm not sure how much enter into the decision-making process, but influence the practice, the everyday practices of judges at the Court of Justice in terms of having more women, more diverse women at the court? What could be claimed that would enter into that decision-making process? And by the way, when with my colleague here, Bill Davis, we were at the Supreme Court hosting the European Court of Justice in their visits to the Supreme Court, Justice Sotomayor said to if the female judge from the European Court of Justice that made exactly the point that Professor Perisin was talking about. There's no different. We decide the same as our male colleague. And Justice Sotomayor brought up lots of data, including the one that her male colleagues would interrupt the female colleagues, the women judges on the court, much more than the other way around. So they couldn't talk as much. Their time was limited, and during the oral proceedings, their work and their thoughts were interrupted. So for you, Tamara.
Thank you. So I obviously don't know. There is no practical data on how the situation is changing. So just years ago, there was not many years ago, there were hardly any women. So it will take some time to see how the fact that there are now women, whether that in any way changes the dynamic, the legitimacy, the perception of the courts. I'm obviously, well, maybe because of my academic background, so I'm not a formalist. I do believe that it matters having a diverse group of judges. I like how Iyiola said that this should be reflective of society, and the judges should be able to grasp the complex legal issues in a better way, because more of their experiences would be represented. So the court is not the one who can solve this problem. We really need inclusiveness of the national professions. I like the idea of maybe having some sort of charters, but maybe just the practical thing. So our statute is adopted by the member states. So it is an annex to the treaties. So I don't know whether some other document could be adopted. And concerning this, that what the judges have in common is their education. So of course you want judges to be well educated and so on, but there is also, I've often heard an argument that this is that in a way that there are certain systemic rules in the functioning of courts which serve to privilege the elites to become judges. So for example, we had a discussion about the working language. So the working language is French, and in many member states, French will be the fourth foreign language that someone learns. So you really needed to start learning languages as a child. So it is not so much your own merit, but the silver spoon of your parents that in a way fostered someone in getting all this education. I don't have any other comments at this point.
That's great. Laure, you want to add?
Yeah, I would have a question also for Iyiola, like where do you think we can, how far we can think of diversity? Because if we, okay, woman, then the ethnical, and then why not age, sexual orientation, and then if you go, I mean, where do you stop? And then if you go a bit further, how do you even manage to create this diverse group? And then Black, but why not also there is a very big Turkish community in Germany, for instance. So that's my question.
Okay, thank you. So I don't see this as being zero sum. So it's not, you know, one or the other. I think that
how we can think of it.
So the issue is racial homogeneity. I don't think there is homogeneity in age. I mean, we're trying to address problems that we see. The court used to be have a higher age ratio. I think we've seen that coming down over the years. It's hard for us to know about sexual orientation. It's hard for us to know about transgender issues. It's hard for us to know about religion. These are all very valid points, but we don't know whether those aspects are actually already present on the court or not. We haven't asked, but what we do know is what we can see. And that is that there is a marked absence of racial diversity at the court. So these issues might come up, these issues might be there to be promoted in the future, but I don't think we should, I don't think it's an argument to not pursue an agenda for racial diversity just because we might then say, oh, well, there are all these other aspects as well. I think these are, it's not, as I said, it's not a zero sum, but this is the agenda that I'm talking about at the moment. And I would just go back to what I said before. It's not about representation. So it might be that there is a white male judge who is also homosexual. So, you know, it's not a kind of diversity by numbers approach. It really is about reflecting experience on the court in order to improve decision making. So just as in the classroom. So in the classroom, we see critical mass as being important because it enhances the educational experience, because it makes conversations and debates and discussions more interesting, more wide-ranging, more varied. While courts are also discursive spaces, judges also talk to each other, even if they don't influence each other when they're coming to a decision. So that kind of critical mass is just as important for a court in the same way that it's important in a classroom.
Yes, great, thank you. I think unless we have some burning questions for Judge Perisin and Professor Solanke. Yes, we do have one from our wonderful Mexican LLM here. So if you guys could spend one more minute and we'll just hear the student. Actually, we have two. Can I take two so they could respond before leaving?
I can stay for a while, that's fine.
Thank you. Okay, please go ahead with your questions.
Sorry, thank you very much for doing your comments, Professor Nicola. That was very kind. My question.
Can you guys hear? Okay. Yes. Okay.
Thank you.
Yeah.
I'm actually writing an independent study on the current composition of international organizations, and I'm very interested in tribunals. And one of the subjects that I am assessing is the legitimacy that having the same amount of women and men in tribunals or in courts internationally implies. I've come across these two concepts of normative legitimacy, understood as what justifies authority, assessing both perspectives of men and women in order to be able to create a neutral adjudication. And also sociological legitimacy, which means why the courts or tribunals are believed to have legitimacy or to have the right to adjudicate. So I will be interested in knowing what your perspective is, considering these two aspects, what will be more relevant. I found fascinating this link with both representation and with the reflection of society. But aside from that, it's not too much to ask. I would also like to know if you think that this either way of legitimacy is relevant for any case of adjudication, or if it has a particular stronger approach in gender-based crimes or in gender-based adjudication.
Terrific, thank you. That was our first question. And Mosi, yes, our wonderful LLM from Peru, please.
Thank you. I have a question. You have been talking about women in high court especially, but I would like to go one step back and perhaps thinking about women in the judiciary in general and how to promote the presence of women in the judiciary, maybe from law schools. What's the role of law schools promoting women to become part of the judiciary?
Terrific.
No, the experience maybe it's possible. Each one of you in your countries, maybe what like the numbers Professor Nicola has told us in the US, maybe in the countries, which is the number of the women in the judiciary in general.
Great, thank you. So first question about normative legitimacy versus sociological legitimacy. And second question about the law school, how law schools promote this gender equality. Please, Tamara, if you want to start.
Yes, sure. So in the European context, I think there has been very little consideration for either the normative or the sociological legitimacy. For the normative, so there are simply no norms which would require gender balance. There is this one and for the general court that aims to ensure gender balance, but it is not really a very strict obligation. Sociologically, I don't think there has been any research done, or at least I have not read it, showing that more diverse courts are perceived as more legitimate. And concerning the relevance of gender in deciding cases, equally, there has been very little research. So when I bring this topic up, my colleagues often mention, oh, maybe gender would be relevant in let's say like family law cases before national courts, maybe divorce and the sharing of custody between a husband and a wife, but they don't see how it could be relevant in, let's say, a state aids case or competition case. So I don't have enough data. There is simply no one has asked that question and no one has done that research. So I don't know. But it is certainly an important question to ask, and it is also difficult now to do historical research because historically women were not represented. And concerning the role of schools, so obviously, so the schools are in a way the entry into the profession. So if there is no participation, no reflectiveness of the society in schools, then there will not be at any of the courts. I have to say, from my own home country in Croatia, I remember when I was a student, there were more female students than male, but the professors were mostly men. But, you know, as my generation has grown up, now women are increasingly professors. And the same thing was happening at courts. It used to be that judges at the municipal courts, which are the highest level, were typically women. At the Supreme Court, only men. The presidents of all courts, only men. But somehow this has been moving up, although not entirely, because there are always some barriers to the entry of women into the profession that are not being really seriously taken into consideration. And in Croatia, we have not had the challenges of ensuring racial inclusion, simply because Croatia for a long time has not been attractive to anyone coming from another country. So it was typically a very white homogeneous area. We did have ethnic issues, ethnic diversity, and problems in how to balance that at all levels, in the parliament, at the courts, and so on. So we do have, the country is ethnically diverse, and there are considerable minorities.
Thank you, Tamara. Iyiola, please.
Thank you. Just to add to that, and thank you both for the questions. I think I heard them properly. Just to add a bit to the first one, there was a project that was conducted in England, looking at decisions of, I think, the Supreme Court, and trying to identify how they would have been determined if the judges had been female. It's called the Feminist Judgments Project. So there has been work done at the national level to show how the difference that women judges make, but I don't think that has been replicated at the European level, and that might be an interesting project to undertake for gender and also for race. In relation to the role of law schools, I think they do play a very important role, because, as I said in my presentation, the problem doesn't exist at the problem isn't made at the European Union level. It's just magnified and manifested there. It's a problem that begins in the member states, and it does begin in law schools. And I think one thing that law schools can do in relation to promoting racial diversity in the judiciary is simply to take action to introduce measures and initiatives to encourage more young Black, and with Black I include Turkish. Sorry, I didn't answer that aspect of your question earlier, Laura. When I use Black, I use the political Black, so I mean African, Caribbean, Asian, Turkish, and that would include the Roma as well. So I think law schools across the European Union have to do more to identify the racial and ethnic marginalized communities, and introduce initiatives to introduce them into the law school, and then when in the law school to again introduce measures to expose them to the judiciary. So I've done things like that myself. I work with the Inner Temple here, which is a kind of organization for barristers. I work with the Inner Temple to organize outreach events, so that school children from underrepresented groups can come into the university and just meet judges, which serves not only to demystify the university environment, but also to demystify the role of a judge. Because it's important to see that actually judges, as we see with Tamara, are people just like the rest of us. But without that exposure to a judge, then you would think that this is these are people who have two heads or something like that. So that's something that law schools can do, I think, to address the issue.
Terrific, thank you. And before going to Laure, I want to take one more question from our audience. Yes, please.
The question was, there's some of the adversity with the female gender and the male gender when it comes to the judicial practices in a lot of countries.
Judicial practice.
For instance, Saudi Arabia, we just in the 5 years starting to have female judges. Okay, so when I came here to the United States, there was a pushback and not a lot of dialogue, again, with female judges here. So I established my own court under Federal Rule of Court, friendly foreign court, in order to build that bridge between Saudi Arabia and here. So I'm the first female juris selectors, the chief juris selectors here in the United States. And what we did was we counterpart with our Ministry of Justice and Royal Court in Saudi Arabia and extended it here and meshed it with their municipal laws and our Sharia Council laws, and it works pretty well. So I'm wondering if other countries follow this apparatus, would it help to bridge the gender gap between male judges and female judges, and where female judges can be established, whether or not.
Great. So basically, a proposal, what kind of initiatives can be done?
Would other countries here in the UK or where you are,
Crash.
would it be as possible to do initiative in this way that would help the gender gap? I'm not saying that everybody should establish their own court, but there's something of trying to
Great.
do this to make it more level.
Perfect. So thank you. And so basically the initiative in the member state, when we're talking about an international organization as the EU, but as you're right, the diversity starts at the member state level. I also had a question from Trinity College by Audrey Plan, who's asking about, in this conversation, we heard a lot about empirical research on diversity and the lack of the ROF, especially on the European bench, that lags behind in Europe compared to other, for instance, empirical studies in the EU. Do you think further empirical research on the impact of women in European domestic courts or on the ECJ or the European Court of Human Rights is necessary to further support efforts pushing for diversity on the bench, or is lack of information not really the issue? Relatedly, if such research could prove useful, what are the factors holding back? Why don't we have already a research agenda for diversity on the bench at the ECJ or the European Court of Human Rights when there are such powerful courts? And yeah, I wish how many European research grants are there on this matter. Laure, I wanted you to follow up on any of these issues and then give the last word to Tamara and Iyiola and let them go.
Yes, I get a very interesting question, like whether we should think of gender discrimination only when we deal with gender-related cases, like child abduction, non-discrimination between women and men on the working place, and it is a very interesting issue because I think, and is why I explained you what was the jurisdiction of the Court of Justice of the European Union. You see that they basically, up until recent moment, the Court of Justice of the Court of Justice of the European Union didn't really have to deal with these kind of issues, right? And even if the case law was very promoting the non-discrimination between women and men on the working place in the 70s, it was just because that would have helped the internal market to work better, right? So they were pushing for non-discrimination between men and women, just to harmonize the standard and to facilitate, okay, the circulation of workers on the internal market. So basically, it was not about women really, but was about the internal market. And that would explain, so sorry, I don't really answer to your question, but that would explain maybe why the gender diversity has never been in the agenda before the early 2000s, more or less, you know, we started to think about, you know, diversity maybe with the Lisbon Treaty, really just before 2010. And going back to your question on law schools, they do have an important role, but I would take the French example. And we have a lot of women studying law, and they are doing very well till the postgrad level. And because we have this competitive exam to become judge in France, they also perform quite well because the exam are anonymous, at least in the first phase. And so we have much more women judges than male judges. However, France perform very badly in the European Court of Justice. There is no female judges at the moment, no female advocate general. And why? First of all, because that has been said before, they don't really reach the high courts, and in the high courts, the really high positions, and mainly because it's also a political nomination. Maybe they don't have, all the networks, way to do, to be known by the right person, to be appointed. And so that brings back also to the problem of the selection process in France. So, and also the second reason is, I think, mainly, and as we said a lot of time before, there is a moment, the women, they manage, they study well, they even reach the position, but they don't manage to go, to reach the high positions. So there is kind of, even if things are getting better, there is a moment anyway, when we have to choose between men and women, is always men winning. So the law schools program, they are good, but I think it's a matter of really changing the minds of student girls, and to be sure that they want to not only to be judged, but then once they are judged, that they should not be refrain from asking for more, like getting a presidency of chamber, then go to the high courts, and then once they're in the high courts, to always develop the network in order then to be promoted at the Court of Justice.
Terrific. Let me just take the last question from the audience, and then let the Judge Perisin and Professor Solanke say the last 2 words. Yes, please.
In terms of the nomination process, like how much participation there is from the civil society to push governments to present candidates that are the most?
Great question here. And Prajolita, yeah.
Higher.
Yeah. How can it be balanced? And second is that when you talk about gender, since there's nothing mentioned, is everyone assuming that it's only about cis men and cis women, or are we talking about the inclusivity as well?
Great. So please, Tamara, the last word, and then we'll let you go. Thank you for staying for so long, and same for Professor Solanke, Iyiola. Go ahead, Tamara.
Well, I just need to confess that I couldn't hear the last question, so I apologize for that. I didn't know whether someone else heard it.
So we had a question that was to Laura, so we'll let her a thing, and let her talk about it. And the other question was about
Nomination.
oh yeah, the nomination process. Is there any leeway? Yes. Thank you. Is there any involvement by civil society in the nomination of the EU judges?
So I will conclude by saying that I think that your panel is great because you, in a way, put the issues out there in the public arena. So these are not issues that are discussed in everyday life of the European Court or in the everyday European legislation or politics. So I think that this is why more research and more academic writing in the field is useful, just to raise awareness that this is an issue. I'm not suggesting that empirical research is relevant for proving with some mathematical accuracy that state aid cases would be decided differently. I don't even know whether that is true, but academic research is relevant just for putting the issues out in the public arena into the discussion. Now, concerning the nomination processes, of course, it is difficult for me to comment the selection of judges, but each member state has its own different procedure. So I don't know how it is organized in in other member states. I can tell you in mine that there is a public call, so anyone can apply. Then there is a national selection panel, which is composed of a member of a Supreme Court, a Minister of Justice, representative of the Ministry of Foreign Affairs, representative of the Parliament, and representative of all the law schools in the country. And they propose candidates to the Prime Minister. But the Prime Minister, before proposing it to the EU, needs to hear the opinion of the national parliament. So there is also hearing in the parliament. At the EU level, before the 255 committee. So the 255 committee is composed of former judges of the court, of the general court, and of national highest courts. But also there is one representative of the European Parliament. So there is no special provision anywhere guaranteeing civil society to participate, but it might be that in some member states it is regulated nationally. Anyhow, it is great that the academics are putting this issue on the agenda.
Thank you, Judge Perisin and Professor Solanke.
Thank you, and thank you, Tamara, for sharing all of your insights. And I really hope that you're enjoying your work at the court, and I look forward to hearing more from you there. Really. So I think the last thing that I want to say is in relation to trying to explain why we still, after so many years, at least in relation to gender diversity, why there is still such an issue, especially at the higher levels of the court. And I wonder whether we need to start thinking not just about lack of information or lack of empirical data, etc., and really start to consider seriously the use of positive action. So this is something that has been more recently used in appointments to the European Kingdom Supreme Court, and they use positive action at a very specific part of the recruitment procedure. It's not at the beginning, it's only right at the end where you have two candidates that are of equal merit, and if one is female, then the positive action allows the court to appoint the woman. Now, some would argue that the use of positive action comes too late in the process, and that might be something that we can debate, discuss, and conduct some more empirical research on. But I think that if we seriously want to make progress within our lifetimes, then the use of positive action provisions would be advisable. Thank you.
Terrific. Thank you. And so this is the labor of love, and having these two wonderful academic and a judge here so late, and when in Europe is already over 7:30. So thank you for being here. We will let you go now, and Professor Clement-Wilz and myself will just conclude. But again, thank you so much for your curiosity and joy, as Professor Solanke mentioned in our interview. Thank you for being here.
Thank you for organizing. Bye-bye. Enjoy the rest of the event.
Thank you for the invitation and for all the questions. Bye.
Bye. I wanted to just leave the Professor Clement-Wilz say her last words, because I didn't want to keep them for I just wanted to let them go, but I know she has to answer some questions. And just I wanted to say my co-author and historian of European law is here, Professor Bill Davis. Thank you for coming and sitting patiently. And I just wanted to put out there, legal history is also very important to uncover some of the judicial diversity issues at the court. We found out through one of our colleagues, an historian, and did some judicial biographies, that the first president of the Court of Justice, a man, an Italian man, was also very supportive of the fascist regime, Mussolini, and supported basically the invasion of the fascist government to the legal nation. And then after the war, it was sent as a reward to become the first president of the Court of Justice in 1952. So legal history has unearthed a lot of lots of backgrounds of our judges, and so I would say that this work is also very important, the work that legal historians do about who are on this court, who are the people on this court's judicial biographies. And Professor Davis just finished a biography of a federal justice here in the United States. So I just wanted to put out there. But before we continue with our conversation, Professor Clement-Wilz.
It's containing the question on the role of civil society. As Tamara said, you have always to distinguish between the national level and the European level. So what we are more interested in the national level, because as you understood, it's really depending on what each member state wants to do. And I try to compare the different nomination process, and I can tell you the civil society is never there. I mean, at the most is what the Croatian system has is like open competition, everyone can apply, and then there is a panel of judges or people from university advocacy that would hear the candidates. That the most transparent and open we can have, that the France doesn't really do, and hopefully will do in the future. Concerning this top-down approach that I'm suggesting, I said it that there is nothing said in the treaties. You know that as lawyers we have to be creative, whatever the statutes and rules says, and you see when the judges, they change their case law with the same text, it means they are being creative, for the worse of the better, but they are creative. So as I said, this 255 committee has a kind of, I don't know if it's in English, soft power influence. Okay, it didn't say to the member state, you have now to change your selection procedure, your selection process. But as a matter of fact, they almost all did it. Just because this 255 committee every year publish a report saying, you do what you want. It's just, if you bring me a candidate that has been selected with an open competition, I might be more keen to accept it as a judge. And so if you do then the statistic, and there had been some negative opinions, so candidate that was just not selected, like the French candidate 2 years ago, the states, they understand that they have to change. So my point is, out of the blue, they can also suggest that diversity is an important factor, you know, and they don't need a legal basis for that. And maybe the soft power can have an influence, and that would join was also what Iyiola was saying on positive action, because positive action has to be made within the different member states, and they could maybe use the report of the 255 committee saying, okay, maybe now we should put diversity in the selection of our candidate. So that could, this positive action could be made by using the 255 committee report.
Thank you so much, Laure. So if we don't have any other questions, unless there's any other thought or question, we will bring this program to an end. I do think this is an important topic for anyone who wants to pursue the research. I have to mention that all this would not be possible without the work of love and intense labor of Professor Federica Bindi, who has been very...
It has been a joint effort.
It's been a joint effort, but she's been perseverant, persistent. She leads the research network of women in leadership. And tomorrow, this feast will continue with another event at the European delegation that she will mention. But really, working with our institution can be challenging at times. Putting together 3 different programs and 3 different students' organizations and several NGOs was really the work, a lot of work of love. So thank you, Professor Bindi, for bringing us all here, bringing our wonderful speaker here today. And I will let Professor Bindi just invite you tomorrow.
Yes, please join us tomorrow at 9 local time, 3 p.m. in Europe. We're going to have amazing speakers. We're going to close the event with Neera Tandem, which is special advisor to President Biden, thanks to the Women in Politics project here at the American University. So please join us tomorrow again. Thank you for being here, both from home and in person, and we will send to everyone who had signed up the video and the webinar if you want to watch it again. Thank you again. Have a nice
Love that. Thank you so much. Thank you for being here.